Most of the time, what I really wanted to do is I wanted to do the plaintiff side of employment discrimination. And I wanted to represent people who had been victimized, which is not a good word, but who had suffered injustice, and that's what I wanted to do. So I later came to represent Dorothy Veely against the Department of Prisons. We tried that case, and she won. I represented Mary Hausch in her case against Donray Media when they did not appoint her to be the editor, and that case was resolved before going to trial. I represented Tina Kunzer Murphy, who is now the athletic director, but she sued, or she was discharged, or her contract was not re-upped, shall we say, and Tina sued UNLV for sex discrimination, and that matter was resolved. I represented Susan Strickland against Saks Fifth Avenue. We tried that case, and Susan won a huge victory against Saks Fifth Avenue. So those were the kinds of cases I represented. Michael Jordan, not the basketball player, but African-American employee of the Department of Aviation. We tried that case against the Department of Aviation, and Michael secured a jury verdict, which is, I believe, the largest civil rights jury verdict against a government employer in Southern Nevada. And it was a non-promote case, and the jury awarded him over $250,000 on his retaliation case. And that was a race and retaliation case. When I went into private practice, I primarily practiced at the MGM Grand Fire litigation for the next 3 years. But I also maintained my love of always wanting to do somehow employment discrimination. And the Federal District Court appointed me to a case to represent Cheryl Bass Hickman, who had a race and sex case against the U.S. Postal Service. She had been fired in her 59th day, and she was she had represented herself, she and her mother had represented her during the EEOC proceedings, and now the case was going to proceed to trial. Chris Kempfer and I tried that case in 1985, right before Christmas. Cheryl won, and she was reinstated to the post office, and they required her to report to duty for reinstatement at 4 p.m. on Christmas Eve, 1985. So she walked back into the post office that she had been fired from 9.5 years later. So it was a huge victory. It was my first civil rights case. It was a bench trial because before the 1991 Civil Rights Act was passed, the amendment, you didn't have a jury trial. You didn't get jury trials in sex discrimination cases. So that's how the law changed as well in 1991. So that was my first case, and it was a magnificent victory for her and a justification, certainly a vindication of her rights.